Well, hello, everyone. I'm really excited to be here today with a friend, John Estes. John, welcome.
Thank you, Gabe. Glad
Yeah,
to be here.
absolutely, and I'm happy to have you on today. So, John Estes is an attorney and partner with the Kapsak Estes LLC law firm in Longmont. And I know, John, you specialize in estate planning and elder law planning. Is that correct?
Yeah, that's correct. We primarily focus on estate planning and estate administration, so helping out with those processes. And then both my partner and I are elder law attorneys as well, which means that we helped out with protective proceedings and Medicaid and some other ancillary issues that often come along with the estate planning side.
Yeah, that's awesome. And I know you and I met a handful of years ago, whether it was through Senior Law Day in Boulder County or whether it was Aging at Altitude. But I know you and I have crossed paths several times over the years, both serving the senior community. And I love what you presented on a couple years ago when actually it was the elder law topic that I think connected us. And then we started talking triathlons together and realized that you were a much better triathlete than I ever was. So, but with that being said, why don't you give us a quick background on yourself, if you don't mind? But today we are going to obviously be focusing on the estate planning side of things, even though I know you specialize in elder law. And we'll come back another day and talk about elder law specifically. But give us a brief background on yourself, if you don't mind.
Yeah, that sounds great. So my partner Dan and I have been in practice for a combined 40 plus years at this point. I
Awesome.
joined with him 10 years ago and became partner fairly recently. Both of our practices really does focus on the estate planning and estate administration side. So about 80% of our caseload is helping families out with this planning aspect and then helping out in implementing the plan after something has happened, either death or incapacity. The remaining 20% of our practice area is that elder law stuff. So that's helping out with guardianships or conservatorships in the event of incapacity. Or I think where you and I first got connected was working with Medicaid and how our practices overlap in helping people maximize their utility in, keeping a high quality of life during that Medicaid process.
Absolutely. I love that. And yeah, thank you. It's quite an array and depth of information and experience that you cover. And again, there's a lot of overlap in what you said, right? So the estate planning, the elder law planning, the Medicaid planning. But today I want to dive into estate planning, right? Because some of the things that you already talked about is, putting the plan in place, number one, but then managing the plan, right? So let's start at the basics. What is estate planning?
Yeah, absolutely. This is my favorite topic to talk through with clients because this is where I think we can be the most helpful before something goes wrong.
Yeah,
And estate planning is really focused more on the planning aspect. So it is making sure that you've got documents, people, teams in place in preparation for one of those major life events, for death or incapacity. So a typical estate plan will include working with an attorney, and that will be preparing your will, maybe a trust if that's applicable. And I think we will talk about what those situations might be, as well as documents for while you're still alive that are important, such as your general power of attorney, healthcare power of attorney, and living will. That's where the attorney is helping you prepare those documents, get your thoughts in order, and make sure you're not missing anything that we may think of because we think of this every day that you don't think of because no one wants to think about death and dying. Um, Other people that might be on that team are financial advisors or help with what do we do with the major asset we have, our home. That's where I often have Gabe involved or other professionals, but it's really getting all of the right people in place and getting those important documents in place.
awesome. So first and foremost, writing down and documenting, right, with the processes and documents for if something happens, right, in an emergency,
Exactly.
right, incapacitation or death. So with that being said, what if somebody doesn't have much to really worry about? I mean, is this just for people with wealth, or is this really for anybody and everybody should be doing some sort of estate planning?
Yeah, a great question, common question that I get asked is, I don't got have a lot of money. Why do I need to have an estate plan? And even if you've only got two nickels to put together, you know, doesn't matter. I still think that at least most of these documents, most of this process is going to be helpful for you. Uh, Many people have this assumption that if they die without a will, it all goes to the estate, or they actually know that it goes to their family. But even in smaller estates, making sure you've got your wishes spelled out in a legal document is important. Some of the worst fights I've had have been on quote unquote small estates where the parents understood if I die without a will, my kids get everything. What they didn't understand is the statute is pretty quiet on who takes care of that. Who's the person that's going to step in as the personal representative, which is Colorado's term for executor, to actually make sure that that happens. And if we don't have that spelled out with the parents' wishes, what I've seen, unfortunately, frequently is children fighting, not over who gets what, that's already set, but who has control of how that happens.
Hmm.
And that's a needless waste for the parents' estate. We end up spending too much of that limited resource already on attorneys' fees fighting this. And it's an emotional resource for the children who, instead of mourning the loss of their parents and going on with things, are at each other's throats. So even where you don't have a large amount of money that we're looking to pass on, getting this down so that your wishes can be honored is an important step, and it will save everyone headaches down the road. And we'll talk about this later as well, but especially important is those documents that don't deal with your assets, but rather deal with how do we take care of you if something happens. So a big part of the estate plan, and the thing I really push on my clients, is if you decide you want a will, don't want a will, that's fine. I can talk through the potential pitfalls of not having. But for many people, if you don't have one, it's going to go to your kids. It's going to pass the way you want to. But what happens if you get in a car accident and can't pay the mortgage because you're in the hospital? Or what happens if you go into the doctors and you have dementia or Alzheimer's or some other form of incapacity where you can't understand the treatment that's being provided? Who do you have to make those decisions for you? And I ask this to my clients as, first, do you have somebody? And second, start thinking about who you want that person to be, because there's a lot of assumptions around those processes that are incorrect. For example, your spouse does not have a right to speak for you, even though they're your spouse, without supplemental documentation, those powers of attorney. So a big component for those who may say, I don't have a taxable estate, I don't need to do this, is still make sure you're taken care of during your lifetime through these powers of attorney.
Yeah, that's great. So two components, it sounds like, or obviously more than that, but two major components to the estate planning, right? Is what happens to your assets and your belongings, right? And how do you want those to be dispersed or distributed? But then if you're still alive and you can't manage your finances anymore, how is that to be managed? And what you're talking about, obviously, are the powers of attorney. And so, and it sounds like it doesn't have to be a family member necessarily, a spouse or an adult child, but it just has to be someone that you have to name, right? Talk to me a little
Absolutely.
bit more about that process of naming a power of attorney or an administrator to the estate, I suppose, as well.
Yeah, absolutely. So one of the things I think you can provide the most benefit to your loved ones is making sure you have the right people in as your trusted people, whether that's as the personal representative after you die or whether that's as your agent for while you're alive. And I use the word trusted intentionally because when I'm talking with clients, oftentimes one of the first things they assume is, well, I'll just do it in chronological order. My oldest kid, then the next, then the next. And I try to be clear, if your family members are those you trust the most, which for many people it is, wonderful. But there is no obligation to do it in that order. And I really want to impress on anyone preparing these documents, whether it's a friend, whether it's a client, whatever. You want those people to be the people that you trust implicitly because they are going to be the people that have control. And there are some safeguards in place in these documents, but as with any safeguard, it's much better if that safeguard never has to get used and having the right people that are going to not cause problems, not cause issues, not, you know, act maliciously with respect to your property, your medical decisions, is the best way to prevent there being an issue down the road.
Yeah, that's great. And with that being said, as we're talking about power of attorney, talk to me about the difference between a durable power of attorney or a specific power of attorney, if that's the right terminology.
Yeah, absolutely. So when we're talking in the estate planning context, we're usually talking about what is called a durable general power of attorney, which
Okay.
most people understand to be a financial power of attorney.
Okay.
And the durable piece of that is that the document survives your incapacity. So it doesn't expire when you become incapacitated, can't make your own decisions, which is important since the primary reason for this is someone to act when you become incapacitated. There are also limited powers of attorney or specific powers of attorney, and those tend to be situation specific, and many people sign them without even realizing it. So a great example, maybe from your industry, is when you're closing on a home loan or on housing paperwork. You are signing a limited power of attorney authorizing them to make any clerical changes to the documents after signing, should there be any typos or anything like that. Basically saying, you've got my permission to sign for me if we screwed up this initial paperwork, but my authority is limited to those documents. So
And by
those
the way,
will,
just to interject on that, so nobody gets alarmed of signing loan documents, that's for a defined period of time as well, typically 30, 60, 90 days, right? So,
it's limited both in duration and in scope. So you're
yep,
authorizing this person to do
yep,
one very specific thing for you for a very specific time period.
yep,
So those are the types that don't really come into estate planning because they are situation specific. But
gotcha.
when we're talking about it, we're talking about what is going to be in place indefinitely until you make a change to it. And really with that idea of, I need someone in to help me out should the time come that I need that help, that I need someone to act for me.
Gotcha. No, that's awesome. So we've been talking a fair amount about powers of attorney, right? So effectively, who's going to handle my stuff, my affairs, if I'm still alive but incapacitated?
Yeah.
And incapacitated meaning you're not mentally or physically able to handle your affairs. Is that a fair layman definition, or is there a better definition, maybe?
Yeah, I prefer the layman definitions anyway. The legal ones tend to get a little bit too technical, but
Yeah.
effectively, it's you are incapable of managing your own affairs. You're incapable of understanding the ramifications of your own actions. And
Okay.
so you don't have the requisite mental ability to, act in a legal capacity for yourself.
Okay.
Um, Oftentimes with the general power, we don't have to go that far. That's the idea behind it. But many times attorneys, and I am one that leans this way, will make those immediate, meaning we don't need you to be incapacitated for your agent to act for you. If it's inconvenient for you to act, or you just need them to take care of something, but you're otherwise still able to act, we authorize your agents to act for you. And I talk through that with my clients, and that's something to think about. But most attorneys that I know and that mentored me when I was first getting started really advocated for that immediate power of attorney for the general. For the healthcare power, we do require that incapacitated. And that one is you are no longer capable of making informed medical decisions. So as long as you're able to communicate your wishes and understand what your doctors are telling you, doesn't matter what your power of attorney has. We are listening to you. We are honoring your wishes in that moment. Once you can't anymore, it's having that medical decision maker ready to go so that we don't have this lapse in coverage. We don't have doctors saying this procedure needs to be done, but I need authorization and I can't get it. Uh, and that one is, again, making sure it's someone you trust. And the other component of that conversation I have with my clients is making sure that you've actually talked with your agent. Make sure that they know they're your agent. So I always have them have the documents themselves as well. But then also that they know what your wishes are, because their job is not, acting in some neutral third party objective standard. Their job is to try and say, okay, if my loved one was still able to make their decision, what would they do? Because I'm trying to get into their mind and make the decision they would make. So having that direct line of communication on some really difficult topics to discuss with your agent is a key component of what we do and what we try and talk our clients through.
Gotcha. That's fantastic. So again, as we're talking about what happens if you're still alive, right? Let's talk about the after you pass situation, right? So you touched on
Yeah.
earlier about a will or a trust. So maybe you can give, again, a brief definition or explanation of the differences between a will or a living trust.
Yeah, absolutely. So one of the main differences that people may be aware of is with a trust, you can avoid probate. So a trust is a standalone agreement or entity. Different states classify it differently. Many states classify it as both an agreement or entity. None of that matters. What matters is that any assets that are in your trust do not have to pass through your state's probate process. They get to avoid that step. So many times trusts get pushed on clients or get marketed as a probate avoidance tool. And in some states, that's really useful. Colorado is not one of those states. Colorado has a very simple probate process. It's administrative, which means we file the will, there's a court filing fee, and unless there's a fight going on, unless people take issue with what is happening, the court's involvement is limited to here's your authority, act with the estate, tell us when you're done, and we'll close it out. So there's not a lot of extra cost through going through probate in Colorado. But there are still valid reasons for having a trust in place. And some of the main ones that I talk through clients with is first, real property. If you've got real property in more than one state, so Colorado and somewhere else, or just in foreign states, trust is going to be almost necessary for you because real property has to go through probate in the state that it resides in, that it is. So even if Colorado probate is simple, if we've got real property in, say, Iowa and Idaho, we'd be doing 3 separate probates, tripling the cost of administration after you die to deal with that. A trust can take care of that and get it out of probate in all 3 states. Second major reason comes back to that capacity. So if we have a known medical condition where we are looking at a high likelihood of incapacity in the near future, sometimes trust can be simpler to administer. You can get a co-trustee to act with you right away, similar to that agent, but a little bit less cumbersome, especially banks tend to be more familiar with. I'm not sure why, but we have less problems with banks working with successor trustees than we do having them work with agents. So if we've got a early onset dementia or something where we anticipate that there's going to be a need for someone to act for you sooner rather than later, we might recommend a trust. A major one is how much dead hand control you want to exercise. And this comes up often in the case of blended families. So if we've got 2 parents with children from prior relationships and they want to be sure that when they die, they're maybe it goes to the surviving spouse first, but that on the second spouse to die, at least what they had declared goes to their children, goes to their children. Trusts are a great way to do that, where we can make them irrevocable on the first person to die, locking in that predetermined percentage split. And then the last major issue is privacy. If you don't want people to know what's in your trust, either you're some sort of local celebrity or there's high family tensions where maybe we're going to write some people out of the document and we don't want them to know they're being written out of the document, or we're okay with them knowing that they're out of the document, but we don't want them knowing who is getting it instead. Trusts are a great way to do that because trusts are private. They only are able to be seen by the trustee, the person who's controlling everything, and the beneficiaries, the people who are set to receive any. Wills are not private. Once they go through the probate process, anyone for a $15 retrieval fee can go see what you put in your will. So they can see, hey, John left everything to his siblings. Okay, cool.
Wow.
So those are the main reasons we would do trust over will. And I know we're running on time. One of the main reasons I hear people say about trust is I want to accomplish certain tax objectives, maybe estate taxes or some other tax objectives. And that is a reason trusts get involved. But I would just tell clients, it's not going to be the determining factor, because from a tax perspective, anything we can do with a trust, we can also do with a will that incorporates what we call testamentary trusts that are created after your death. So it is a factor, but it's usually not a driving factor.
Awesome. That's great. So at a high level, right? What it
Okay.
sounds like is there's very specific reasons where a trust is a better uh, document. Is that you know,
A better mechanism for transfer.
mechanism?
Yeah. Yeah.
Okay, fair enough. To pass your assets on, right?
Yeah.
And it sounds like if you own real property outside of Colorado, or you're listening to this and you are outside of Colorado, like California or Florida, which I understand both are very difficult probate states.
California, Florida, New York. If you're in one of those three states, you are getting a trust. Anywhere else, talk. Well, let's talk.
Yeah, there you go. So, again, very good explanation and differences. And so, with that, what if you do nothing at all? Again, we talked about probate, and if you
Yep.
don't have anything written, maybe that it's as simple as that. The family or the estate has to go through probate. What's that process look like as far as Colorado specifically? Maybe you can touch on.
Yeah, absolutely. So if you do nothing, you don't have a will, you don't have a trust. Colorado uses what is called its intestate rules. Intestate just meaning died without a will.
Okay.
And as far as who gets everything, it's pretty straightforward. It's going to go to your closest living family members. So first to your children, if there are any, then grandchildren, then parents, siblings, nephews, nieces, on down the road until we run out of family members. If we run out of family members, it actually does go to the state at that time, but it's highly unlikely that you're not going to have some form of second cousin or something out there that we can track down. Now, maybe you may not want your second cousin, may not know them, you may not want them to get it. That's a good reason to have a will, but it is going to try and go to family member first.
Interesting. So if I can interject, so people I talk to from time to time say, I don't have children, I don't have heirs, I
Mhm.
want my stuff to go to, Humane Society, right?
Yeah,
Or wherever, some charity of their choice. But what
absolutely.
you're saying is if they don't put that into a will or a trust and they have third cousins twice removed that they don't get along with,
Yep.
they're going to
They,
get those assets if in fact they're still alive upon your death. Is that fair to say?
that is exactly right. And that is one of the reasons I say it doesn't matter the size of the estate. What's important is that we're honoring your wishes. And it's easy for parents. They want everything to go to their kids. There's reasons to have it go through a will because we can put um, protections in place where the kids don't get $1 million outright at 21. We can spread that out over time. But end of the day, it's going to go to who a parent would most likely want it to be. But if you don't want your assets to go to family members, either there are none or you just don't get along, which we see fairly frequently, then you need to have that in a will because if you do nothing, it's going to go to whoever your closest family member is.
Wow, amazing. I didn't realize that. And with that being said, it's also at any age, right? I would say, and hopefully you would agree with me, at any age, you need to have these plans put together because anything can happen on any given day. And I, for one, have, an 18-year-old and a 16-year-old. To your
Yep.
point, I wouldn't want them to inherit a lot of money without some limitations or controls. And then at some point, God willing, 20, 30 years from now, when hopefully I'll be a grandparent. I wouldn't want it to go to the grandchildren without limitations. So briefly, maybe you can touch on things like special needs trust or generation skipping trust, just at a high level in the sense of where you get into these complex situations where there's special needs per se.
Absolutely. So one of the main ones that we deal with, I deal with a lot of young parents, children under the age of 10. And oftentimes the conversation will change over time as I work with them over a period of years. But it's all right, I'm an overwhelmed parent, but I'm still young enough that I know what I was like at 21. I wouldn't want to inherit all of that, right?
Sure.
Yeah, and maybe they're doing life insurance, making sure that they've got stuff there for their kids. Wonderful. Life insurance is another piece of the estate planning piece that I don't do that, but I advocate that with my younger clients, especially.
Okay, there with you.
So it could be something as simple as, simple needs trust, what we call HEMS, taking care of health, education, maintenance, and support, making sure that the kids' needs are taken care of. and then allowing for some special purpose distributions once they reach landmark ages, 21, 25, whatever those may be. I also do a fair amount of work with parents who know that they are parents of special needs kids. They either have a child with a diagnosed disability, or we're in sort of that gray, some of those gray area diagnoses such as ADHD, autism, where there's a whole spectrum of what they can expect for their lives. And it could be high functioning or easily able to work within society, and there's going to be no lifelong implications whatsoever, to the great people who can't hold a job. And how we deal with that estate plan is going to be very different. But one of the ways we might deal with that is a special needs trust, which specifically sets the assets aside for the benefit of that individual in a way that does not conflict with eligibility for some government programs such as Medicaid or Social Security. So any resource dependent programs, they say you can't have more than, it's often $2,000. It hasn't changed in my lifetime. And if you go over that, you're no longer eligible for this benefit. Well, sometimes for those families, that benefit is crucial, especially if it's Medicaid, if it's the primary health insurance. So having a trust that says, okay, you're not getting this money. We're putting this over with a trustee to manage it for you. And we're doing so in such a way that it can't possibly be counted as a resource for you for those programs, but it can cover things that improve your quality of life that maybe those programs don't. It can cover vocational training. It can cover durable medical equipment that maybe Medicaid doesn't cover. It can cover clothing, hygiene, whatever. So making sure that there's assets available to them, but in a way that doesn't get rid of their crucial Medicaid benefits.
Fascinating. Now, you just went somewhere where I wasn't sure if we were going to get to today, but talking about Medicaid and Medicaid planning and how that ties in, I think we're going to have to come back and have another episode just on Medicaid planning.
I think that sounds great. I'd be happy to rejoin and do specifically talking about the intricacies of Medicaid. Also probably on a high level, but giving knowledge so you know what to look for.
I love that. And I will look forward to doing that, hopefully here in the near future. But as we wrap up today, what's the best thing that people can do to plan now, right? To make it easier for their family if they become incapacitated or die. What's the best thing they could do right now? And with that being said, if people want to reach out to you, maybe you can share the best way for someone to contact you.
Absolutely. Best thing that you can do right now is make sure that you have a plan in place. Make sure you have at least those 4 documents that we talked about. And one we really didn't, but the 4th document is the advance directive, living will. I won't go into that, but make sure you've got those documents in place and that they are current to your current wishes. Make sure that you have gone through and really thought about who the people that you've got in place as your personal representative and as your agents are. And be ready to have that conversation with an attorney if you do make the appointment to get these documents in. And I do recommend that you have these documents professionally done. This is not an area where I'm an advocate for do-it-yourself. I've seen too many do-it-yourselfs where they got so close to the finish line and just missed one tiny thing. And that tiny thing ends up being in litigation for a year, costing more money than really should have happened.
Wow.
If you want to talk with me about that or with my partner, we are in Longmont. We've served Longmont for 30 years. Best way to reach us is to give us a call. Our phone number is 303-651-9330, and either ask for Dan or for John. Or you can find us on the web at kapsakestes.com, and that is KAPSAKESTES.com.
Awesome. Well, thank you, John. Appreciate all the information and insights. As we wrap up today, I just want to thank you so much once again. And sounds like we'll look forward to having another episode on Medicaid another time.
I appreciate it. Always good to talk with you, Gabe, and great to talk about something that I actually really enjoy talking about. So anytime.
Wonderful. Thanks again.
All right. Take care.
Bye-bye now.